Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. The group behind the blockchain that stores digital content made the request in a tweet Friday. According to LBRY, the U.S. Securities and Exchange Commission case against them does not establish that XRP sold on secondary marketplaces constitutes a security. Followers of XRP have been quick to join the call for action following the tweet. This comes after the judge provided additional information in their recent judgment in SEC v. LBRY. After the court decided in favor of the SEC on November 7, a status conference was scheduled on November 21. In spite of the court's order, the regulator has not provided further clarification about the secondary market sale of LBRY credits, LBC. Due to concerns that the SEC would extend the decision into the secondary markets, LBRY filed a motion to limit the SEC's remedies. The court mentioned an explanation clarifying that his ruling does not apply to secondary markets at the last hearing on Monday. According to public statements made by Deaton, who appeared in court on behalf of Naomi Brockwell as a friend of the court, advocating for a separation between secondary market transactions and the court verdict. Deaton, an eyewitness, alleges the judge denied signing a permanent order to prevent LBC's sale. The pro-XRP lawyer further says that the court accepted commercial contracts lawyer Louis Cohen's declaration that LBC did not represent a security. Based on an analysis of all U.S. securities cases decided following the Howey decision, the authors conclude that no court has ever ruled that the asset underlying an investment contract is a security. This point has been made in a number of Twitter discussions and court files, most notably in Deaton's brief on behalf of Brockwell contesting the SEC's broad allegations. To put it another way, this is great news for XRP holders because it means the cryptocurrency cannot be regulated as a security. Remember that the SEC sued Ripple in 2020 December, alleging that XRP is an unregistered security. It's worth noting that neither party has budged an inch in their nearly 2-year legal battle. The question of whether or not these arguments will be enough to have XRP listed on Coinbase and other U.S. crypto exchanges remains open. To put things in perspective, following the SEC's legal action against Ripple, other U.S. cryptocurrency exchanges, including Coinbase, decided to delist XRP out of fear of legal action. Coinbase's 2018 inquiry into XRP and subsequent finding that the asset was not a security is cited as an exception by many in the XRP community. Additionally, the research was utilized to back up the cryptocurrency exchange's 2019 SEC meeting, where they requested approval to list XRP. That's fine with the Securities and Exchange Commission. As of the time of this writing, the cryptocurrency exchange had not addressed the complaints of the XRP community. Predicting that it will wait until the Ripple case is resolved is more prudent. For his part, Ripple CEO Brad Garlinghouse has been adamant that a choice will be made before the end of the first half of 2018. The briefing phase, it seems, is concluded, and the only remaining decision is the judge's. Ripple, the American technology company behind the Ripple blockchain and its native token XRP, has appointed a new president in the person of Monica Long. This development comes up amid the company's heated legal battle with the U.S. Securities and Exchange Commission. The appointment was disclosed by Ripple in an official press release on Thursday, and further publicized through its Twitter handle today. Starting the year off on a high note, we are excited to share that longtime Ripple and GM Monica Long's is now president. Read more about her appointment. Long has been with Ripple for over 9 years, having joined the firm as Director of Communications in September 2013. She entered the scene when the Ripple workforce comprised only 10 employees. According to the press release, Long reportedly championed several initiatives that helped push Ripple forward, working with regulators and getting the trust of global financial institutions. Even in the current challenging crypto environment, Monica has helped guide Ripple to a very unique place of growth and financial strength. She's been an instrumental advisor to me over the years, and I'm grateful to have the opportunity to partner with her even more closely as she embarks on her role as president. Brad Garlinghouse, Ripple's CEO, remarked. Garlinghouse further acknowledged in a tweet today that Long has been one of the major catalysts of Ripple's growth over the years, highlighting her brilliance and effectiveness. There's a lot I could say about how singularly impactful Monica Longs has been to Ripple's growth. For now, I'll just leave you with, she is brilliant, strategic, and has the ability to pick up and learn skills like no one I've ever seen before. Congrats, Monica. Long and her team were responsible for the launch of the widely utilized Ripple on-demand liquidity (HODL) enterprise crypto network in 2018. HODL, which is touted as Ripple's flagship product, is utilized by global entities and governments to facilitate cross-border settlement. Promoted to general manager in August of 2020, Long spearheaded CPC partnerships with Bhutan and Paolo, and the launch of the first stage of Ripple's Evm sidechain. The introduction of ETH on Ripple was also overseen by her. Moreover, the San Francisco Business Times has named her one of the most influential women in business. The recent development comes up amid Ripple's long-standing legal battle with the SEC, which has done little to stunt the technology company's growth. Optimism is dominant in the Ripple camp, as several individuals, including CEO Garlinghouse, remain confident of a favorable ruling. Garlinghouse also believes the case is likely to end in the first half of the year. Most recently, investment banker Declarant, a non-party in the litigation, filed a response to Ripple's opposition to their initial request to redact their personal information from a declaration in support of the SEC. Attorney Deaton achieved a significant victory on behalf of LBC token holders and the whole crypto sector in the just-finished hearing between LBRY and the SEC conducted yesterday at the Warren B. Rootman United States Courthouse in New Hampshire. Deaton, who acted as amici counsel for tech journalist Naomi Brockwell, successfully persuaded the judge that LBC secondary market transactions are not securities. In order to avoid giving clarification for LBC, the SEC sought an injunction that does not differentiate between LBRY, the company's management, and consumers. Attorney Deaton remarked that the injunction was imprecise and wide, forcing him to seek clarity for Brockwell and other LBRY users' LBC secondary market activities. The inventor of crypto law said that he referred to a paper prepared by commercial contract lawyer Louis Cohen that examined all security cases in the United States since Howard. According to Deaton, during Cohen's research of security cases in the United States, no court ever acknowledged that the underlying asset was a security. The article states that your ruling seems like you may be suggesting that LBC is security in and of itself. Deaton said to the judge in court, "If you don't intend that, Judge, then we need to explain it." After some back and forth, the judge said that he is not inclined to issue an injunction, according to Deaton. He went on to say that the judge's declaration is a huge victory since the court will not issue an injunction against LBRY users. Deaton said that he got the Securities and Exchange Commission to admit on the record that LBC secondary market transactions are not securities. Hearing on LBRY, the stakes for all crypto. Several Bitcoin fans have praised Deaton's efforts in the LBRY case, which might be employed in future crypto-related matters such as Ripple v. SEC. In a tweet today, Hogan law firm partner Jeremy Hogan praised Deaton for pressuring the SEC to state on the record that LBC as a token is not a security. The SEC acknowledged on the record that the token itself is not a security at the SEC's UV LBRY hearing. Excellent work, Mr. Deaton. Furthermore, Fox Business journalist Eleanor Terrett praised Deaton, noting that no one battles harder for the Bitcoin sector than the creator of crypto law. Takeaways. 1. In the Helbrackham case, the SECOV attorneys admitted author that secondary market transactions of LSHIF tokens do not constitute a security. 2. No one is more dedicated to the crypto community than Jan is more dedicated to the crypto community. Then consider how simple it would be for the SEC if it weren't for him. LBRY has the following message for SEC. Ideal for the SEC.